It is 9:47 on a Thursday evening. You are on the couch, shoes off, finally unwinding after a long day. Then it comes. 3 deliberate knocks. You check the peephole. 2 officers, badges. 1 leans toward the door and says it. And most people open up the moment they hear those words. This is educational content only. For specific legal guidance, consult a licensed attorney in your jurisdiction. Everyday homeowners make one costly mistake when police knock. They hear a specific phrase and they open up. They do not know what it is designed to do. They do not know what they hand over the instant the door swings wide. And they have no idea the Supreme Court ruled they had 0 legal obligation to open that door. I have analyzed hundreds of documented door encounter cases, civil rights filings, body cam footage, and suppression hearings. I have identified 5 exact phrases police are trained to use at your front door to get you to open up. You hear one of these phrases, that door stays shut, every single time. I will give you the 5 exact trigger phrases, what they mean legally, the precise words to say back, and the case law that backs every rule. Stay through all 5, because the last one fools people who already think they know their rights. Most officers follow the rules and serve a vital role, but the law gives you a castle. Today you learn exactly how to defend it. Before we get to the 5 phrases, you need 30 seconds of legal foundation. Without it, this sounds like paranoia. With it, it sounds like constitutional rights. Because it is. The 4th Amendment protects you from unreasonable government intrusions into your home without a warrant, your consent, or a genuine emergency. Your home is, in the words of the Supreme Court in Florida versus Jardines, first among equals in constitutional protection. Police bypass the warrant requirement using a tactic called a knock and talk. Officers approach your door, knock, and hope you open up, giving them information, a look inside, or their actual goal, consent to search. In Kentucky versus King, the court confirmed officers have the same right to approach your door as any private citizen. A Girl Scout can walk up, knock, wait briefly, and leave. That is all the law allows. But a Girl Scout does not use rehearsed phrases designed to make you feel you have no choice. That is exactly what the 5 phrases do. Curtilage is the legal word for the area surrounding your home, your porch, your walkway, your side yard. Courts have ruled this area gets the same 4th Amendment protection as your living room. Everything police say at that door is a legal event. Every word you say back is potential evidence. Every time you open that door is a choice. After today, you make that choice knowing exactly what it costs. Phrase number 1, we just want to talk. Marcus has done nothing wrong. He is making pasta on a Tuesday night when 2 officers appear at his front door. Through the peephole, he can see them clearly. One leans close and says, "We just want to talk." It sounds harmless, just a conversation. So, Marcus opens the door. That is exactly what they were counting on. The moment Marcus opened that door, 2 things happened instantly. First, everything those officers could now see inside his home became fair game under the Plain View Doctrine. No warrant required, just a legal vantage point and open eyes. Second, Marcus validated the encounter as consensual. He told the law he was willing to participate. That is the opposite of what you want. We just want to talk is designed to establish a casual tone that makes refusing feel rude or suspicious. After reviewing dozens of encounter records, the pattern is clear. Officers follow this phrase with questions designed to build a timeline and establish behavior. Each answer can build their probable cause. They are not required to tell you that you are the suspect. Start recording the moment you realize police are at your door. That recording matters. Courts have held that a homeowner's documented refusal and calm demeanor carry weight in suppression hearings, eliminating the word-against-word contest entirely. Wrong response. Marcus opens wide. Sure, what is going on? Officer. Where were you this evening? Marcus. Home all night. Went to the store around 7 for a few minutes. And just like that, Marcus has contradicted his own timeline and handed them a thread to pull. Correct response. Door stays shut. Through the closed door, say this. Officer, I am not opening my door. I do not consent to any searches. Please state your business in writing or leave my property. Say it calmly, say it clearly, say it politely. That is the exact phrase. Officer, I am not opening my door. I do not consent to any searches. Please state your business in writing or leave my property. If they push back, say it again. If they insist, say it a third time. You are not escalating, you are exercising a right. In Kentucky versus King, the court held the occupant has no obligation to open the door or to speak. None. And in Clark versus State, courts confirmed that refusing to cooperate cannot, on its own, create probable cause. You are not making yourself look guilty. You are exercising a constitutional right. The bottom line on phrase 1, "We just want to talk," means they do not have enough to come in. That phrase is an invitation to give them what they need. Do not accept the invitation. That protects your Fourth Amendment rights at the threshold. But here is what most people miss. Officers rarely lead with a direct ask about you. Phrase 2 is far more disarming because it positions the concern as coming from someone else entirely. The moment a third party is the source, your guard drops. And that is precisely when theirs goes up. Here is phrase 2. Phrase number 2. Your neighbor called. It is Saturday afternoon. Rachel is watching a movie when she hears a knock. Peephole. 2 officers. One says, "Your neighbor called about some noise earlier. We just need to clear it up." Rachel thinks, "I have nothing to hide. It is just a noise complaint." She opens the door. She does not know that the officer chose that phrase because it makes the issue feel external, not about her. And she has no idea that the moment she opened that door, the officer spotted something on her table and the entire conversation shifted direction completely. Your neighbor called is the third-party deflection. It positions the issue as coming from outside. It feels less threatening. It feels resolvable. That emotional distance is exactly why it works. Officers use neighborhood complaints to create the impression that opening the door is cooperative rather than a legal concession. It is not. It is a legal concession every single time. Record everything from behind the closed door. Your footage is evidence that you never invited anyone in. Remember, while you speak through the door, a second officer may be scanning your perimeter, noting visible windows and items in plain view. Give them nothing to observe. Door stays shut. Wrong response. Rachel opens the door. Officer, how many people were over? Any alcohol tonight? Rachel is now answering questions she had zero obligation to answer, while the officer scans every corner of her living room. Correct response, door stays shut. Through the closed door. Officer, if there was a concern, I will keep that in mind. I do not consent to any searches, and I am not opening my door. Please leave my property. That is the phrase. I do not consent to any searches, and I am not opening my door. Please leave my property. If they say the neighbor is still worried, say it again. Calm, polite, and firm every single time, and subscribe right now so you never miss these constitutional protections, because phrase 3 exploits something genuinely good in people. It is the most emotionally crafted phrase on this list. A noise complaint is not a warrant. In Texas, Virginia, California, and Indiana, courts have consistently held that a third-party complaint alone cannot justify entry. In Indiana, the state constitution provides stronger home protections than the federal baseline. In California, officers must articulate specific facts beyond a vague complaint before any legal threshold is crossed. The bottom line on phrase 2, your neighbor called, is not a reason to open your door. It is a reason to stay behind it. You now have the 2 most common casual openers, but phrase 3 is different. It does not come from authority. It comes from concern. Officers use it because it exploits something good in people, the desire to prove you are fine, that nothing is wrong. And the moment you try to prove it, you hand them the legal foothold they needed. Here is phrase 3. Phrase number 3, we just want to make sure you are okay. A man named Daniel is in his kitchen on a Sunday afternoon. He had a minor argument with an ex-partner 2 hours earlier. She called a non-emergency line, not to report a crime, just to express concern. Officers arrive through the door. We just want to make sure you are okay. Just open up so we can see you are fine. Daniel thinks, if I do not open the door, they will think something is wrong. He opens the door. That single decision costs him. Most people believe a welfare check is soft and non-threatening. That belief is wrong. In 2021, the Supreme Court ruled unanimously in Caniglia versus Strom that the community caretaking function does not apply to the home. Officers cannot use vague wellness concern to bypass the warrant requirement. A neighbor saying someone seemed upset is not a genuine emergency. For warrantless entry to be lawful, there must be specific credible first-hand information indicating imminent danger. This tactic is being weaponized. Anyone can call a welfare check on anyone. A vindictive neighbor, an angry ex, a controlling former partner. Once that call is made, officers arrive with a socially sympathetic reason to demand you open up. If you do, you have done their work for them. Record everything. Your recording proves no emergency existed from the outside. Critical if this ever reaches a suppression hearing. Wrong response. Daniel opens the door. Officer, mind if we step in and look around just to make sure everything is good? Daniel, sure, come in. They are inside. Anything in plain view is evidence, and Daniel never gave informed consent. Correct response, door stays shut. Through the closed door, I am fine. Thank you for checking. I do not consent to any searches. I do not need assistance. Please leave my property. That is the exact phrase. I am fine. Thank you for checking. I do not consent to any searches. I do not need assistance. Please leave my property. You have just demonstrated you are conscious and safe without opening the door even 1 inch. In New York, Florida, and Washington, courts applying coniglia have consistently ruled that vague second-hand wellness concern does not equal exigent circumstances for home entry. In French v. Merrill in 2021, the First Circuit stripped officers of qualified immunity for persistent knocking after clear refusal, confirming that documented refusal is the foundation of a potential civil rights claim. The bottom line on phrase 3, we just want to make sure you are okay, is not a warrant and not an emergency. Prove you are fine through the closed door. That door stays shut. Coniglia settled the welfare check question for the home, but here is the gap almost nobody considers. Even without entering, officers can build their case from your porch. Phrase 4 is the trigger for exactly that, designed to manufacture probable cause from outside your threshold. You need to understand how the Plain View Doctrine operates before you hear those words. Phrase number 4, I can smell something. I think I see something. James opens his front door slightly and just a crack to speak with officers who say they are following up on a vehicle in the neighborhood. The moment that door moves, one officer says, Sir, I am detecting an odor. I may be seeing something inside. And now James is in a legal situation that did not exist 30 seconds ago. Here is the Plain View Doctrine. Once an officer is in a place, they are legally allowed to be, including your porch during a knock and talk. Anything they can see, smell, or hear from that lawful vantage point can establish probable cause. No warrant required, no additional consent required, just legal presence and acclaimed sensory observation. This is why cracking your door is so dangerous. The moment that door opens even slightly, you have extended their lawful vantage point into your home. Every item visible from that angle is now fair game. Every smell that drifts out. Officers are trained to use this phrase as a signal to their partner, to their body cam, to the prosecutor, that they now have an articulable basis for further action. Record everything. Use your Ring camera or doorbell audio. Do not let a claimed observation go undocumented. Wrong response. James opens the door 2 inches. Officer, I detect an odor coming from inside. Can I step in and verify? James, I guess so. And James has consented to entry based on a claim he can never disprove because he opened that door. Correct response, door stays shut. Through the closed door, I do not consent to any searches. If you believe you have probable cause, please obtain a warrant. I am not opening this door. That is the exact phrase. I do not consent to any searches. If you believe you have probable cause, please obtain a warrant. I am not opening this door. If they claim to smell something, that does not give them the right to enter without a warrant. It gives them the ability to get one. Make them go get one. When they get a warrant, a neutral judge decides whether their claimed observation meets probable cause. That is the constitutional check working as designed. Opening the door bypasses that judicial review entirely. State variation. In states where marijuana is fully legal, California, Colorado, and Washington, the smell of marijuana cannot form probable cause at all. An officer claiming to detect it through your closed door has no legal foothold in those states. The bottom line on phrase 4, I can smell something. I think I see something, is an attempt to manufacture probable cause from your porch. Keep the door shut and make them get a warrant. That protects you from plain view entry. But there is one phrase left that bypasses all of it, because it does not try to get inside your home at all. It tries to get you outside of it. And once you step across that threshold, every protection your castle gives you vanishes instantly. This is phrase 5, and it is the most dangerous one on this list. Phrase number 5, would you mind stepping outside for just a second? A woman named Angela is at her front door. The officer has been calm and polite the whole time. He smiles. I just have a couple of quick questions. Would you mind stepping outside for just a second? Angela thinks. It is just a second. She steps out. And the moment she crossed that threshold, she lost every constitutional protection her home gave her. Inside, police need a warrant to detain someone and consent to enter. Outside that porch, an officer can detain her based on reasonable suspicion alone. No warrant required. They can question her under different legal rules. They can observe every visible inch of her interior. If Angela is detained outside, that requires no arrest warrant. She is no longer behind her threshold. Payton versus New York only protects you inside the home. Step outside, and that protection evaporates. Officers are trained to understand this legal shift. Getting a suspect outside is worth a dozen failed attempts at the door. When they ask you to step outside, they are executing a legal repositioning of the encounter entirely in their favor. Start recording before you respond. This is the highest stakes moment in any door encounter. Wrong response, Angela steps out. Officer, what were you up to tonight? Angela, just home all evening. Officer, we had a report of a vehicle matching yours. She is now outside, being questioned with no castle doctrine protection. Correct response, door stays shut. Through the closed door, I am comfortable speaking right here. I am not stepping outside. I do not consent to any searches. Please state your purpose or leave my property. That is the exact phrase. I am comfortable speaking right here. I am not stepping outside. I do not consent to any searches. Please state your purpose or leave my property. Say it calmly. Say it clearly. Say it politely. Repeat as many times as necessary. Payton versus New York established that the Fourth Amendment draws a firm line at the entrance to the house. Absent exigent circumstances, that line cannot be crossed without a warrant. Do not voluntarily step over it yourself. In Virginia, Texas, and Florida, courts have held that refusing to step outside is not obstruction and cannot form the basis for probable cause or detention. The bottom line on phrase 5, would you mind stepping outside, is an invitation to surrender your castle. Stay inside, stay behind the door, stay protected. 3 situations change the rules. Valid warrant signed by a judge. Do not resist. Fight it in court. Genuine exigent circumstances. Screaming inside. Fleeing suspect. Imminent danger to life. Lawfully arrested. Comply. 4 phrases for your phone. 1. I do not consent to any searches. 2. Please leave my property. 3. I plead the 5th. I invoke my right to remain silent. 4. I want a lawyer. Say them out loud right now. Your silence is not protection. Salinas versus Texas confirmed that staying quiet is not invoking your Fifth Amendment right. You must say the words, calmly and clearly. Stay calm, stay polite, stay firm. Composure is your best legal defense at that door. Like this video. Subscribe so this legal education keeps reaching you. You just learned your front door rights, and subscribe so more homeowners get this before police knock. Because the next video covers how these protections apply when encounters escalate. Watch it now. Let me know in the comments where you are watching from and what time it is. Hype this right now if it changed what you would do when you hear that knock, so it reaches the next person before it is too late. This is educational content only, not legal advice. Consult a qualified attorney in your state. Your home is your castle. The Fourth Amendment built the moat. Now you know exactly which phrases are designed to make you lower that drawbridge, and exactly why you never will.